Hello and welcome to our video on right to work checks, considerations for employers. My name is Adele Standard and I'm a senior associate in the immigration team at Fox Williams. My colleague Yawar Abbas, an associate in the team, will present this video with me. This video is relevant for all employers, all UK employers, and discusses the obligations employers have to comply with prevention of illegal working, as well as the consequences of failing to do so. So in this video, we will cover who right to work checks apply to, how to carry out a compliant check, additional considerations for sponsor license holders, students, and the consequences of getting it wrong. I should mention that the topics discussed and the information provided in this video are correct at the time of recording, but subject to change. Who need to carry out right to work checks and on who? All UK employers are required to comply with the prevention of illegal working guidance and carry out right to work checks on all employees on or before their first day of work. Follow-up checks should also be carried out on anyone with time-limited permission. Correctly conducting a right-to-work check establishes what's called a statutory excuse. This essentially means that should one of your employees turn out to not, in fact, have a right to work, for example, if their permission is withdrawn without your knowledge, or in the event that they've provided you with false documents, you'll be protected from incurring a civil penalty for illegally employing them. If you carry out the check after an employee's first day of work, you will not establish the statutory excuse. If you do miss that date, it's still important to complete the check to satisfy yourself that the person does in fact have the right to work for you. However, without the statutory excuse, should it later transpire that they don't have the right to work in contradiction to their documents, you may be liable for civil penalty. These are currently up to £20,000 per illegal worker, but are due to increase to up to £60,000 per illegal worker at the beginning of next year. So getting this wrong can have significant financial consequences for a business. Whilst you're only required to check the right to work of staff under a contract of employment, service, or apprenticeship, it's also good practice to carry out right to work checks on anyone who'll be working on site for you, even where they're not your direct employee. For example, agency workers, or if you engage self-employed contractors. Whilst you won't technically be in breach of your obligations if you don't undertake checks on workers that are not directly employed by you, it's best to avoid the risk of the Home Office visiting your site and finding illegal workers on your premises, as it could be disruptive to your operations and risks reputational damage. In the event of a merger or acquisition where TUPE applies, although the checks of the seller are deemed to have been carried out by the transferee, and therefore any statutory excuse is inherited, if the seller did not carry out compliant checks, the buyer will be liable for any penalties imposed. For that reason, it's best practice for the buyer to conduct their own right to work checks on transferring staff. There's a 60-day grace period after the transfer in which to do so to establish a statutory excuse. So the right to work of all potential employees must be checked. This is irrespective of their colour, nationality, ethnic or national origins, accent, or the length of time they've been resident in the UK. You mustn't discriminate and must be consistent in how you conduct checks for all prospective employees, including British citizens. As already discussed, right to work checks should be carried out on or before an employee's first day of work. If their permission is time limited, you must also check their right to work again before its expiry. There are 4 ways in which right to work check can be compliantly carried out. A manual right to work check, a right to work check via an identity service provider using identity document validation technology, an online right to work check via the Home Office online system, and via the employer checking service. So if you go into further detail on each of these methods, starting with manual, a manual check involves checking the person's original documents in their presence. In their presence can be in person or via video call. However, you must check the original hard copy documents to be compliant. A copy won't suffice. You must then make a clear copy of the document in a format which can't be manually altered. It should be retained securely on file, either electronically or in hard copy. You must also securely record the date on which you made the check. This should be a statement confirming that the check was made and on what date. Simply stating the date won't establish a statutory excuse. A list of the Home Office acceptable documents which evidence right to work can be found at Annex A of the Home Office Right to Work Guidance. There's a link to this in the description of this video. Identity service providers. Since April 2022, employers have been able to use a third-party IDSP to complete digital right-to-work checks on their behalf for British and Irish nationals that have a valid passport. This is done through identity document validation technology. IDSPs can only be used to check right to work using IDVT, A statutory excuse will not be established if an IDSP is engaged to manually check a document. If a British or Irish national does not have a valid passport or doesn't want their right to work check made using an IDSP, you must not treat them unfavourably and should perform their right to work check via the other Home Office compliant means. A list of Home Office certified IDSPs is available on the government website, and you can find a link to this in the video description. You're not required to use a provider from this list if you're satisfied that another provider is able to perform the required checks. However, we would recommend that you do so. Online checks can only be used for those with status under the EU settlement scheme, a biometric residence permit, or a biometric residence card. What's more, BRPs and BRCs can no longer be manually checked to be compliant. An online check must be carried out. This is part of the Home Office's move to a solely digital system scheduled for the end of 2024. BRPs will soon no longer be issued. To perform an online right to work check, you must first ask the person whose right to work is being checked to generate a share code. They can do so via the Home Office website. You must then enter their share code along with their date of birth into the employer side of the online service. You will only establish a statutory excuse if you view the person's status via the employer side of the service. Using the individual's login or viewing a copy of their status page isn't sufficient. The employer checking service is for those whose permission has expired, but they have an outstanding application for further leave to remain. This service confirms their continuing right to work while they wait for a decision on their application. You can contact the ECS online to check right to work in these circumstances, and it will issue a positive verification notice for those that do still have permission. This establishes the statutory excuse for 6 months. This is usually received within 5 working days. For follow-up checks, if you're satisfied that the employee has submitted an in-time application, there's a 28-day grace period in which to obtain a PVN, which means that you don't have to cease employment for an existing employee while waiting for a response from the ECS. This only applies to follow-up checks on existing employees and not initial checks on prospective employees. For all methods, you must ensure that the photo and date of birth on the check are consistent with the person's appearance, that the expiry date hasn't passed, the person is permitted to do the type of work on offer, and for manual checks, that the documents appear genuine and haven't been tampered with. If there are any differences in names across documents, you should request supporting documents for the name change, for example, a marriage certificate. Copies should be held on file for the duration of the person's employment and a further 2 years after their employment has ended.
Thank you, Adele. My name is Yawar, and I'm an associate in the immigration team at Fox Williams. I will briefly look at the considerations for sponsors, repercussions for getting it wrong, top tips, business visitors, and entitlement for students. Sponsors are required by the terms of their license to comply with prevention of illegal working. Potential sponsors must satisfy the Home Office's suitability assessment, which includes assessment of past conduct, whether a previous license was downgraded, suspended, or even revoked. Both existing and potential sponsors have an ongoing duty to maintain effective human resource systems to prevent illegal working. This includes monitoring the status of workers, including visa expiry dates. This forms part of a sponsor's HR compliance duties. Evidence of valid and correct right to work checks must be maintained on record for 2 years after the end of an individual's sponsorship. Therefore, there are additional duties placed on sponsors outside the right to work regime, such as retaining specific evidence of travel to the UK for those sponsored employees who were granted entry clearance. Breach can have serious repercussions for sponsors. Potential sponsor may be refused a license. Existing sponsors may have their license suspended, downgraded, or revoked. Existing sponsored employees and their families may lose their visas and their right to live and work in the UK. Refusal or revocation of a sponsor license can lead to cooling off periods where a new application cannot be made for a specific minimum period. If an organization has had its previous sponsor license revoked within the last 12 months, this will lead to a mandatory refusal of a license application. Remember, UK courts consider a sponsor license a privilege and not a right, acknowledging that the system imposes a high degree of trust on sponsors. Some top tips for sponsors. Ensure that the check is conducted in a way that is compliant and will establish statutory excuse, as detailed by Adele earlier. Train staff who are engaged in this process. evidence of a compliant check must be retained on each sponsored worker's file. Appendix D of the sponsorship guidance details what other documents must be retained on each sponsored worker's file. Diarize visa expiry dates at least 3 months in advance of the expiry date. Diarize in multiple places so it does not fall through the cracks if someone departs from the business. In fact, our suggestion is to diarize 3 months, 1 month, 2 weeks, 1 week, and 1 day before the event. This will give you and the concerned individual ample time to chart a course of action. This applies whether you are a registered sponsor or not. You should also monitor and ask for updates. Finally, in case of a breach, seek legal advice and escalate. The Home Office do take it a bit more kindly if a breach is reported voluntarily, has been mitigated, contained, and corrective actions have been taken. Prevention of illegal working also extends to business visitors. Business visitors are only permitted to engage in a limited nature of activities, such as attending meetings and some intra-corporate activities, etc. The Home Office has specific guidance on the nature of activities that are permitted. Ensure, therefore, that the purpose of the visit meets the requirements. Monitor the frequency and duration of the visits. Be specifically mindful of citizens of countries permitted visa-free travel to the UK, such as nationals of US, Canada, EU, EEA, Australia, and New Zealand, etc. These nationals are permitted to use e-gates, therefore seldom requiring questioning at UK borders, as opposed to those nationals who require a visa before entering the UK who will be questioned at the border. Failure to prevent illegal working will have a serious implication for all employers, regardless of registered sponsor status or not. This is because a breach itself is illegal working. Sponsors need to be particularly aware as this ties into general compliance with prevention of illegal working. Breach can have, therefore, a serious impact on the sponsor license. I'll now address work entitlement for students. Not all international students are permitted employment. Those who are may be permitted 10 hours or 20 hours a week. Check their entitlement on the Home Office's online service. Those permitted can work full-time before their course starts, during vacations, and after the successful completion of their course. Employers must obtain and retain details of the academic term and vacation times covering the duration of their study in the UK for which they will be employed. It is for the employer to determine if the information provided is sufficient. Information, for example, on the website may differ from that in any letter provided, in which case a further clarification may be required. Master's and bachelor students may have different course end dates. Resits and dissertations may also have an impact. Therefore, it is incumbent on employers to satisfy that the requirements have been met. Remember, students are not permitted to fill a permanent full-time vacancy unless specific exemptions apply. A review of employment contracts would be prudent at this stage to ensure that the student population has not been issued with permanent full-time contracts without an exemption.
So what happens when you get it wrong? The consequences of employing someone illegally can be very serious and in some circumstances a criminal offence. If you're found to be employing someone illegally and have not established a statutory excuse, you could face a civil penalty of up to £20,000 per illegal worker. But as discussed, this is increasing to up to £60,000 per illegal worker from the beginning of next year. In serious cases, a criminal conviction carrying a prison sentence of up to 5 years and an unlimited fine. Closure of your business and a compliance order issued by the court. Disqualification as a director. Not being able to sponsor migrants if you have a sponsor license and it's revoked or downgraded. Seizure of earnings made as a result of illegal working. Review and possible revocation of a license if you're in the alcohol and late night refreshment or private hire vehicle and taxi sector. Appearance on the Home Office's name and shame list of non-compliant employers. So the consequences can be hard-hitting, especially if you're found to have committed the criminal offence of employing an illegal worker. That's where you knew or had reasonable cause to believe that you were employing an illegal worker, so it's an objective test. A statutory excuse won't aid you in those circumstances. You may face up to 5 years in prison and an unlimited fine for committing this offence. There are consequences for the individual worker as well. Not only is the individual at risk of detention and deportation, but working illegally is also a criminal offence where the offender doesn't have the right to work and knows this or has reasonable cause to believe that they don't. Those guilty of that offence face having their wages seized, a prison sentence of up to 6 months, and an unlimited fine. It's therefore very important to get it right and have policies in place to ensure you're correctly checking right to work. That brings us to the end of this video. Thank you for watching. As mentioned throughout, you can find links to the discussed material in the video's description. Please do get in touch with one of our team should you have any questions.